BraveFathers.com. Welcome to the Brave Fathers Show. And now, the prophecy.
How are you doing? Can fathers win in family courts? And what are the 5 things I wish I knew before I went to court? Now, my name is John Paul from BraveFathers.com, and I'm going to share with you today 5 things I wish I knew before going to court. Now, I live in the UK, but the things I speak about, many of them apply all over the world. And I've spoken to fathers from all over the world, and we all share the same plight. And as you may be aware, 1 second, where is this slide here? As you're aware, winning in court as a father is very difficult. Now, in the UK, we have a very different system from, say, in the States. Let me just adjust this. For some reason, it's flashing about. How are you doing? I hope you're doing okay. As I was saying, in the UK, we have a very peculiar system, and many of the laws around the world are based partly, at least, on the UK system. I believe the Magna Carta is from the Great Britain, from England, and worldwide the laws were based on it. But as we have it, the family court division, the family division is relatively new. And regardless, the system is such that wherever you live in the world, Australia, United States of America, India, Canada, New Zealand, in many parts of the world, unfortunately, it's a sad state for fathers. It's not even almost, they don't want fathers in the home. I think by this time it's quite obvious. And yet, of course, I believe fathers can win. That's why I do this. And we can win even if the system does not change. A lot of the strategies that I share are not dependent on the system changing, but of course, there is no guarantee. Always seek qualified legal advice. None of this constitutes legal advice, and all the opinions are my own. These are just my opinions, my views, my experiences, my observations of how I see things. So my story is similar to yours, probably. One morning, was it morning? No, actually, it was evening, I think. I got a note, nobody's home, all that kind of stuff. And then you end up with a police call. Actually, the call went in my favor that time because I was prepared. I think one thing that gave me the advantage that many fathers underestimate, which is one of the things that I'm talking about today, is being prepared. So even though I was prepared to a good degree, there were still things I didn't know. There were things I was not aware of going in, which if I was, I would have moved faster, I would have moved differently. This slide just needs to be adjusted. Forgive me for that. Yes. So there were things that I wish I knew because that would have helped me move faster and get a good outcome much quicker. I would have spent as many years as I did in court because I've spent years in court. Too many. When I think about it now, it just makes me sad about how much time, energy, how much life is wasted by going through court. But unfortunately, that's just the way it is. So, long story short, I managed to get a good outcome, but after many losses, many very close, hurting margins where I could just lose contact with the kids altogether, completely, with no realistic chance of getting it soon. It was a strong opposition, by a good fight that I put up, and I've learned a lot, and I've been able to help fathers get results who were in difficult situations. Some have had the most horrible accusations, and we managed to still maintain contact with the children. It's not very easy. But let's jump into it. Let's jump into it. So, as you may know, I had to get my outcome, ultimately, my main outcome, which was the shared leave with order, through the appeal courts. But the way I was able to get there was by realizing that it's not about the truth. And that's the first thing that I want you to know when you go to court. Because I had solicitors telling me, oh, just be truthful, just be honest. And I hear fathers on the phone sometimes, okay, yeah, I'm just going to be honest. And it's not about the truth. It's about the narrative. I'm not saying lie, of course not. But certain things that you say will be used against you or misunderstood or twisted, right? The people who oppose fathers being in contact with their children, they have a lot of experience. They have a lot of time practicing. They do this day in, day out. They know what you are going to say. They know what the story is. So when they know what your story is, very quickly they will jump in and present a counter argument, which they've done 1,000 times before. So it's not just about the truth, it's about presenting a certain kind of truth. In other words, what's relevant to the court under these circumstances, the way the system operates, what actually makes sense to the court. So, for example, in the UK, you cannot say, I have the right to see my kids. Now, yes, it is a God given right to see your kids, these are your children, but it does not matter in family courts. You have no legal right in this country to your child, to have contact with your children. And you'll be very quickly told that it's a child who has the right to have you in their life. But to be in touch with your child does not mean you have to see the child even once a month or once a year in person. So when a court orders, which it does, a postcard to be sent once a month, for example, and some fathers have that order. I had something similar. I had like was it weekly or every 2 weeks or something like that in the beginning to write a letter was allowed. And fathers have orders like that. Fathers have orders like that, and the law is satisfied because you have contact with your child. Yes, it's written contact. You may think that it's obvious that the child should spend some time with you, but that's not how it works. If you try to argue anything as to why your child needs you, it has to be usually based on the status quo, which is you should have already have had a lot of contact with your child, but even that's not enough. There have to be specific things in place, but frankly, that line of argument will fail in most cases. Again, seek qualified legal advice, but it is not an obvious truth, even though it is the truth that your child needs you. In most cases, you'll be labeled as an abuser. You probably are labeled that way, which is why you're watching this. So that label automatically creates a barrier between you and the child, because in most cases there will be at the very least supervised contact, right? When you'll not be left alone with the kids as long as the abuser label is placed on you in most cases. So even if you didn't do anything wrong, even if the accusations are false, you will still not get to see your children, at least not in the beginning. So the truth is not what drives it, it's the narrative. So your job in the beginning really is to know how to fight that narrative, how to change the narrative, how to tell a story that actually works in your favor, that convinces the people who are involved to be on your side. And remember, the judge works from material. So you have social workers or Kafka's officers, court advisory services, who will advise the court on your situation. So a lot of your work really is about convincing those people, because the judges will listen to those people. And it's very difficult to convince a judge to go against what these advisory documents will say about you, about what these documents will say about you. It's very hard, almost impossible. Now, there is no lawyer that can change that. You see, that's one thing that people don't know. Like, it's good to have a good lawyer, of course, very important. At the same time, the lawyer will perform his or her work within very specific parameters. It's not a situation where you can come up with a good argument that would work in a pub or in regular life that everybody else will be like, yeah, I agree with you, that makes sense. No. That is something that you really have to get out of your mind. And what makes me sad is when I speak to fathers, you know, when they come fresh and they say, oh, I'm going to say this, I'm going to have that, and they think they have a set argument. Listen, it takes a lot of work to come up with the right narrative, because you are essentially going to not subvert the system, but you're going to shock them or surprise them with a twist on the narrative that they don't know how to respond to, right? So I'm not at liberty to disclose details, but for example, you may have a case where you have a lot of strong evidence that shows how abusive the mother has been, right, towards you and so forth, that they don't know that you've gathered that evidence. Let's say you've been preparing, you realize you've got it. You've got witnesses, things like that. That shocks them. Now they don't know what to do. I've seen situations where the person advising the court apparently, I don't know whether they quit or what, but once they see they can't follow the usual narrative, they distance themselves from the cases. So you really have to really understand how narratives work in court, how stories are told, and how to tell your story. What elements of your stories would appeal to the judiciary and which won't. You have to really, really know how to do this. And I talk about it a lot in my material, but of course, feel free to get in touch by clicking the link below and going to bravefathers.com. The next thing is the facts of the case matter a lot. And when I say the facts of the case, again, what's relevant to the case. So if you have been accused of some kind of abuse, you inevitably have some kind of trial, some kind of hearing to find out what's true, what's not. So over here, we call it the fact-finding hearing. In the UK, it's called the fact-finding hearing, right? So in your fact-finding hearing, the facts will be determined of what happened, whether you did the abuse, whether you didn't, whether she was abusive or she wasn't, and so on and so forth, whatever it is that's relevant to the case. So you have to prepare for that ahead of time, right? A lot of fathers really underestimate this. And when I say this, it just hurts me to see fathers lose that could have won or had a better outcome if they only understood you really have to prepare. There are fathers who go into a fact-finding hearing with zero preparation, thinking, I'll just say what happened, I'll be honest, I'll say the truth, and to be self-evident that I'm innocent. And unfortunately, it doesn't work that way. Now, there are other facts of the case that you have to consider. Things like how old the children are. The older the children are, the more their views, wishes, and feelings will be considered by the court. And that is also very dangerous, because in some cases, the kids are manipulated to say they don't want to see the father. And sometimes they may say they don't want to see the father for whatever reason at that moment, and then 10 minutes later, they'll be like, oh, but I do want to see daddy. You know, children are fickle, right? And it's very sad that children are asked essentially to choose between parents because, sure, they may not be asked directly, but they are not stupid and they know what the parent wants. So if they've been hearing bad things about the father for a while, they may be angry with the father. They may be angry with the father that he's not seeing them. And there are mothers who will lie to their children that the father does not want to see them. It's horrible. It's horrible what goes on. But whatever they say may be considered a fact. If you want your children to stay with you, do you have the rooms for them? Do you have the appropriate accommodation? Do you have everything they need? Right? Those are facts of the case. If you are considered, let's say, abusive, in some cases you may actually get some points for addressing that right away. You could say, for example, I'm not saying that's going to work that way, but it could in some cases, where you say, look, when they ask you, let's say during the interview before the hearing, right, to gather information, and you may be asked, um, you've been screaming at the children and the mother, is that true? And you say, well, as far as you can tell, you've never raised your voice over, in an abusive way, but you do recognize that sometimes your anger may be misinterpreted. However, you've engaged in the anger management course just to be certain, right? And you're learning a lot of things, something like that. Or you are taking a parenting course because you've seen those concerns and you're using them as a way to steady yourself, as an opportunity to learn. Now, I know you may not like this. You may be angry, like, why should I say this? I'm not an abuser. Well, if you want to win, you will have to play the game. Because now the fact of the case will become that the father is taking steps towards managing his anger. And that may seem as an admission, but it's not. But it signals that you are taking steps. And if you are found to be shouting unnecessarily or shouting at the mother and the children, the fact that you've taken steps will act in your favor, because the court is essentially looking for you to have insight into your behavior. The court is not looking to just have, for you to be a perfect being. And so if you can show you have had insight, that becomes a fact in the case that works in your favor. If you go on a domestic abuse perpetrator program, let's say you are abusive. I'm not saying you are, but let's say you are, right? Or a father is, somebody else is, and then the father recognizes it and then engages in the program and manage to get on a program, because it's not always easy to get on a program whilst you're in proceedings. And in fact, I think lately they actually stop people from going on those programs whilst they're in proceedings, which is horrible, because, you're just making things harder for the father and the kids. But again, they don't care. But if you do manage to get on one and is accredited and so on and so forth, then you're already ahead of the game. Now, it's not that simple with those programs, by the way, because the way they operate is just, I don't like it. I don't like it because it's a big money maker for them. So they take advantage of your weak position. But there are some alternative strategies which I cannot share live on air, but do visit the link below. Click on the link below, bravefathers.com. Go to bravefathers.com and get in touch, and we'll see how I can help you if you are facing that kind of thing. But the bottom line is, you want things to change so that when you are interviewed by a court officer, Kafka's officer, a social worker, you can tell a story that progresses your case. A lot of fathers are not aware of this, so they wait for the hearing, they get told stuff, they go wait for another hearing, and all of a sudden they're scrambling to put things together. And then it's too late, because whatever was established in the beginning also becomes a fact of the case. The status quo becomes what was the baseline for everything. So by waiting and delaying putting certain things in place, you're just making it harder for yourself to win. So what I wish I knew right away was I could rearrange my life in such a way that would have sped up the process. And I've mentioned this before, but one thing I didn't have was, like beds for kids and things like that. And I had the money, so I thought, oh, when I get access, then I'll buy the extra stuff. But that was a mistake. I should have bought them straight away because it was in the report, no beds. So I should have taken care of that. I really should have. So I wish I knew that. So what I mean is, figure out what the narrative is and make sure your life matches the right narrative. Whatever problems you've had, whether alcohol, whatever, if you know it's going to be used against you and you know you can't escape it, let's say there's going to be testing and you know you be shown to have been using alcohol, of course, quit drinking, start going to AA meetings, whatever, so that you can be ahead, right? Because if you wait for the hearing to be ordered to do something, or you may not even be ordered, nobody will care. But to bring up a suggestion, then you're just behind time. And time is everything. Time is everything. And one thing that you should understand also as the fact of a case is how long you've not seen your children. So the more the case is delayed, the more the court will be told, look, he hasn't even seen the kids in all this time. The kids are not used to him, right? And it makes it difficult, makes it really difficult. Have everything ahead of time. If you know there's going to be supervised contact, have the contact center ready, and so on and so forth. Again, it's a tough battle, but you can do this. So the reason why this is important is people think you can just go into the court and convince the judge or argue. The judge is going to look at evidence of what's going on in the situation, and that evidence is what will guide the decision. And unfortunately, there is a bias against fathers, but which is also the argument for you should know the narrative and change your life to suit that. So the next thing I wish I knew, the third thing that I wish I knew before going to court, was that you inevitably be hoovered in by the mother. She'll try to rope you in somehow, either in a good way or negative way. So in a negative way, she may try to get you to be angry, to do something out of frustration that can be then used against you as evidence of your abuse. That's very common. Another way is what you may think is positive. She may say, oh, can you come over and fix this for me? Because I've had cases like that. Or let's talk, let's meet. And then you get roped in, and inevitably that also ends up with some kind of abusive situation. Another thing is when you may get phone calls, or she may lead you on thinking you get to see your kids. I think recently I was reading something, the guy was, he made a mistake and he was paying a mortgage thinking that will substitute for um, child support or child maintenance. And it doesn't. And a lot of mothers will pretend that the good things you are doing, they appreciate it. They say, like, yeah, I would never take you for child support, blah, blah, blah. Yeah, thank you for paying the mortgage for the kids, and so on and so forth. And I've seen more than one father do this, pay for a house, and so on and so forth. And then the mother waits, makes sure she gets enough resources, and then one day she hits him with the child maintenance or child support. And then he's like, oh, but I've been paying this and that. And then he's like, no, that wasn't child support. That was just you paying the mortgage. It's still your house, blah, 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 blah. And then you're owing so much money on top of all that you've paid. And there are fathers struggling, some working 2, 3 jobs. I remember there was this guy I spoke to, and he drove me actually from a contact session in his taxi, because he was a taxi driver. And he had like 2 other jobs besides the taxi, because of how much money he had to be spending just to see his children. And it was very sad to see him. You could tell he was tired, and all he knew was work, like a machine. So don't get roped into all these promises of, oh, it's good that you help him with this or that, the other, come see me, help out with this, so on and so forth. If you are in court, you are adversaries. That's the reality. If you do this outside of court, then you have to decide on what it is. But as long as you're in court, there's no friendship. And sometimes it actually angers me when I see fathers act like the mother is their friend. It makes me angry when some of them try to get back with the mother, ignoring all the evil that is being done to the kids by separating them from the father, and ignoring all the stuff she's done. And it doesn't make sense to me when people say, oh, she's a great mother. If she's such a great mother, then why is she stopping you from seeing the kids when she knows you're a good man? You know? But I didn't know this, and I got roped into a lot of things, spent some money that I shouldn't have spent, that would have changed everything if I didn't do that. You know, I've had more resources and I could have done things better. But I didn't know this, and at the same time, what I knew I underestimated. And I think that's one thing that we do as fathers. We underestimate how hard the fight is, how difficult it's going to be for us to actually regain contact with our children. So when the mother obviously gives you some hope, it's understandable that you will want to latch onto that. It's very understandable. But what you really have to do is, rather than doing that, you have to start documenting everything. If you pay anything as child support, make sure it's clearly labeled and you have evidence that it is for the child and was accepted as such, so that when it comes down to it, you can prove it. You can prove it. So again, and in UK, that does not affect, money does not affect senior children, but you still have to face the child maintenance service who come after child support. So don't get fooled. I've known of fathers who try to be friends, try to sleep over, afraid of situations where they go, to restaurants together and do stuff together. Like, no, don't do any of those things. They'll be used against you. You are creating confusion in your mind and the children's mind, and you're literally creating ammunition against yourself. And fathers realize this way too late. Way too late. And if you do it, you have to be very strategic of how you're moving. You have to be really strategic. But yeah, and whatever it is, don't try to get back with her. Because often I see fathers say, oh, she changed her mind on the divorce. No, she didn't. She just needs more time. She realized she was not going to get what she wanted, how she wanted. So she needs more time to get it. And you don't want to you don't want to find that out the hard way. You don't want to find that out the hard way. So, you see, this is just an aside, but a lot of mothers know what to do before they get married, before they have children. Because in this day and age, the internet has got so much information, and on TikTok, on YouTube, Facebook, and so forth, there are so many videos, so many resources for women to extract stuff from their fathers, from their children's fathers. It's just common. It's all over the place. So girls who are not married, women who are not married, already start to access this information. They start to learn how to manipulate, how to make sure the judge sees things in their favor, and so on and so forth. So by the time you get that situation where it's over, it's been already planned for a long time, and fathers get blindsided, you know. And it's just the reality of it. It's just the reality of it. So I wish I knew this, because then certain things that I did, I would have done them differently. I wouldn't have gone to certain, gatherings together. I wouldn't have done certain things the way I did. And again, if I did do them, I would have moved very, very differently. I would have done things very differently, in order to make it more likely that I win my case. Oh, excuse me, I've been up for a long time and it's quite late now. So this is the last thing I'm doing before I'm going to sleep. So the next thing that I wish I knew, that I wish I understood before going to court, is that in many ways there is a predetermined path down which your case will go. Your case will follow a certain path. And I started realizing that before the court started. So that's where I was kind of prepared. Because as I kept looking for advice, and I talk about this in another video, but I literally would go to a street where there is chanceries, where there's lawyer offices, and I would literally go into each of them one by one, getting free consultations, just getting advice as much as I could. That's what I did. And by the way, lawyers lie a lot. So doing that helped me, because I had people look in my eyes and lie. But at some point, I knew when they were lying, because I've spoken to others and they told me how things work little by little. Nobody gave me a full picture, but by going to different lawyers, I got little pictures of how the big picture work. But one thing I figured is that there are just a few ways the case can work out. And it really hurts when you know that before you step into the courtroom, there's already a predetermined path for you. Your job is really to figure out what that path is, because there's several ways it could go. So your job is to figure out, in your case, which way is it going? What's the path for your case? And then figure out the right narrative to change that path, to win people over, actually, to help you. Like that, in the end stages, or towards later stages, I was able to get people on my side who were supporting my case. But it took time. It took time and preparation, because the accusations, the false accusations, are usually part of the plan, right? So you are going to court. A lot of fathers get blindsided, like I was, when they hear certain accusations like this never happened. But it's written and said in a convincing way. So once there's an accusation, that automatically means you're not going to have unsupervised contact with your children. No matter how you try to prove you're a good father, how much fun they had with you yesterday, if the mother says no, they'll find an argument to support her, because the court has to err on the side of caution. So even if you didn't do it, right, you've been accused. So now you can't see your kids. So that is the path the case will go down. So once you've been accused, then the next step will be to do a fact-finding hearing, because you have to find out whether it's true or not that this happened. So that's predetermined. You are not going to bring out any argument that will stop it. Now, there may be an exception, to be fair, if the court decides that that accusation that you're facing will not affect whether or not you see the kids. So the court may say, look, there's no need for a fact-finding hearing. However, you cannot rely on that, and the court will have to come to that conclusion. It's very tricky trying to convince the court to say, hey, yeah, I know they're saying all these abusive things about me, but even if it's true, I should still see the kids. There are some exceptions, of course, but it's possible that in your case there's no exception, which is why you're here. Um, the way contact progresses is usually from, let's say you have indirect contacts of videos, postcards, phone calls, then supervised contact, then supported contact. So supervised is you're being supervised right there, like somebody's watching you. Supported contact is you'll be somewhere in the contact center, for example, and then the person comes in and out to check on you, but you're alone with your child. And then in the community contact, which is you're allowed to be somewhere in town, depending on which contact center you work with. They may stick with you, they may stick around, and so on and so forth. That you bring the child back to the contact center. Then you may have some other kind of supervised contact, whether there's a family member and so forth. And then you may have unsupervised contact where the child spends the day with you, but no overnight stays. It's very weird, this stuff. And then it may progress to overnight stays where the child stays over. So all the while, the mother will usually fight to have as little contact as possible. And this brings me to another important point, which I've noticed fathers do in court sometimes, which is they talk to the lawyer, right? So if they're representing themselves, and try to show to the lawyer that they are a good person and so forth, that they are reasonable. Don't waste your energy on that. Be respectful, but keep it to the negotiation and keep it to the facts. Because that person is listening for things. And if they hear something they can use against you, they will. That lawyer is not your friend. And I've seen this many times. And it's one of the ways to make your case harder. Don't do it. Keep it simple. Whatever the arrangement is, it is. Don't try to explain yourself or, try to prove anything to that lawyer, because the lawyer is not going to see it like as you are being reasonable and going to be on your side. They will still find ways to screw you, and I've seen this many times. Now, I have acted nice, but there are some advanced tactics you can use when necessary, but that's not the same thing as trying to get the lawyer on your side. And you can sometimes trick them, not in a bad way, but in a good way. When I say in a good way, basically feign like you don't know what you're doing, to let them let their guard down, or steer the case in a certain way because they don't know that you know the law, or they don't know that you're aware of how things work. So there are tactics. I don't really want to talk about that live here. Maybe in another video I'll think of what I want to reveal to the public. But of course, if you're curious, get in touch. Click on the link below, go to bravefathers.com and see how I can be of help to you. But that was just an aside. The thing is, there is a path, and the lawyer will do everything in his or her power, the opposing lawyer, to make it harder for you, because that's what they paid for. And it's not fair. It's hurtful. It's very painful. But I wish I knew this to a greater degree. Now, to be fair, they did tell me, the lawyers, that's going to take time. It's going to take a while. And so it wasn't as much of a shock when things were taking long. But what I did was I used that time to keep preparing, to get better, to start reading case law, to really understand the process, to seek more advice. And even when I had my lawyer, before I got rid of her, I called her a lot. And some of it now I realize was wasted time, was not necessary. I didn't really understand how the process worked. I didn't. And she didn't care about certain things. That's why I got rid of her. But what she did say that I think I understand now was there's a limit to what you can do. But there is more that you can do than you realize. And in my case, I was not happy because I don't think she was doing her best. I know she was not doing her best. So you have to do your best because, again, there's a predetermined path that your things will go. You know, the bias against fathers is real. You shouldn't get hung up on it too much. I just try to see it as some people will be honest, some people won't. But that bias binds everything that happens. And I've seen situations where the mother is acting horribly. I've seen mothers, come out of court angry and all that stuff. Nobody's reacting. But if a father came out of a courtroom that way, they'll be very quick to say, oh, you can't do this, or you may have to leave, and so forth. I've seen a lot of leniency for mothers when they act in the wrong way in court. The fathers don't get that kind of leniency. And if a mother screams at the child, that doesn't mean she won't be seeing that child. If a father screams at the child, it means he will most likely not be seeing his child, or the contact will be restricted. So the bias is real. I don't like to have the victim mentality about it, and I don't think you should either. Just accept that the court will act on the side of caution, and there are ways you have to convince, people that your child should see you. Unfortunate, unfair, crazy, I would argue, but it's just the world we live in. So the last thing I wish I really knew is that your written statements and your preparation determine a lot of the case, as well as the statements that are written about you. So when you talk to people that are involved in your case, always think of what's going to be written down after you say it. Think about what's going to be written down. Because at the end of the day, what lives on paper is what survives. Everybody will forget everything that is not written down. So it's your job to learn how to write statements that persuade. You see, that's another thing that confuses me, because a lot of times fathers think you can just write down what happens. And a lot of times they go to a lawyer or they have somebody helping them, and they talk for an hour or two, and then that's the statement. But that's not how you persuade. You have to craft your statement. You have to spend time on it. You have to spend hours on it. You have to spend many hours on your statement. Like when I work on a statement for a father, for example, just gathering the information would take me at least 4 hours. That's like bare minimum. Gathering the information of what the opposite side wants, what you've got, the accusation, blah, 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 and looking ahead of what may come in the future, because you have to plan ahead. You have to know there's going to be a fact-finding hearing, or there's going to be a dispute resolution hearing, or whatever kind of hearing you're going to have ahead of time. You've got to think of, what can I plant now that will be useful then? If it's not on paper, it doesn't exist. And you don't want to all of a sudden spring things up, and the judge is like, yeah, but why didn't you raise this earlier? You want to be able to say, no, I did. If you look at my statement dated, blah, 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 it's right there in paragraph 13 or whatever. And you can look and say, okay, you raised it. You have to understand also that a lot of times the statements will be read before the hearing, and a judge will make up his or her mind before the hearing even begins based on the paperwork. Because your hearing is not going to be many hours, it's going to be 30 minutes, an hour, maybe two. So there has to be a starting point, and the starting point is usually the statement you've already made. Now, even if the judge does not read the statements, which does occasionally happen, you still want it written down because that gives you a lot of your arguments. That gives you clarity. You don't want to be winging it in the courtroom. There's going to be enough surprises. So whatever you can cover ahead of time, do it. Cover it ahead of time so that you are not shocked, so that you are not surprised when you're faced with things. And when you are surprised, so that you have energy and focus to do it because you've taken care of everything else. And that's where your written statement comes in. The same way with preparation. Practice whatever you're going to say. And even if you're represented in court and you don't have anything to say, literally practice sitting down and being calm. It may sound weird and strange to you, but listen, if you can sit down calmly like this and just think for 30 minutes, you will struggle to be relaxed in a courtroom when somebody is just lying about you. And it's difficult. Look, all these things, if you try to approach it the conventional way, you will not win, or you are playing on your luck. You may get good results because, of course, many fathers do get good results, and many don't. Overall, fathers don't get what they want, right? And that's everywhere now. That's why we have all these falling birth rates. People don't want to get married. Relationships are not started because a lot of guys are realizing that, wait a minute, if this ends up in court or if there's some kind of injustice, it's going to be even more unfair to me. But your written statements give you that extra edge. They really give you an edge when they are written properly, when they present your case properly. I've seen situations where certain arguments are being made against the father, and the judge will say, yes, but the statement says this and that and the other, right? So that negates whatever the opposing lawyer is trying to say. But if it was not written, then now you have to argue against it. But the judge already had made up his mind on certain issues because the statement made it clear that those issues were taken care of. And it's really, really important. Statements can change things, and especially when it comes to the narratives, because they are going to come at it from a certain angle, right? And the good news is most fathers are not prepared. So a lot of times, the people who are working against you expect you to be underprepared. And remember, we already know that there tends to be a predetermined path. So they expect you to be underprepared, and they know the path down which everything should go. So you can gain a huge advantage by preparing properly, having statements that are persuasive. And now they're like, oh, wait a minute, we are going to have to put in some work here. And now you have that bit of advantage of shock. And sometimes, if the opposite side is lazy, they don't even put in that much work. And it helps that I think a lot of people know deep inside that the children should spend time with you, that they should see you. So it's not really a bad thing if they get a bit lazy, right? But that's how you win. And whatever statements you have to be able to back them up. Don't just make stuff up. So that's why I mentioned earlier the facts of the case. Because I've seen situations where the thing looked hopeless, but I said, look, we have 3 months to the hearing. Let's change this. Let's do this. Sign up for that. Talk to person X. Do all these things over the next 90 days. So that when we are sending the court papers, we can say, look, in the meantime, here's what we've done. And the judge is surprised because, like, whoa, they've never seen that before. The other side doesn't know what to say because they're not prepared for you to have all these things in place. So now you have an advantage. But when you take your statements as something which is what most people do, where you just walk in, talk for an hour or two, that's what my lawyer wanted to do. She's put 1 hour. And I had horrible allegations against me. I'm like, how are we going to do this in an hour? Right? And even if you do have an hour with your lawyer, and that's how you're going to do it, then spend some time on your own drafting, put bullet points. So by the time you get into that meeting, you say, look, these are the points that I want to go into my statement. And you're ahead of the game. Really, really don't underestimate the importance of written statements. Don't use ChatGPT for that stuff. Don't use a bot or AI or whatever. You have to persuade using your own language, but also knowing what to say. These are not things that are standard language. You have to understand narratives. You have to understand the narrative that is being told about you. And your whole preparation includes that, because if they are trying to present you as a certain kind of person, and usually there's a bit of truth to it, not that you are that kind of person. So, like, for example, I'm very confrontational, right? So it's easy to portray me as somebody who is overly aggressive, because if you come at me, I will confront you. I will confront you. But that does not mean that I just get aggressive for no reason with people, right? So realizing that that's true about me, then I have to say, okay, you know what? Maybe I should be a bit less confrontational than I am. What could I cut down? Is it necessary to be as confrontational as I am? And usually the answer is no. Not too much, maybe cut it down by 5%, 10%, whatever it is. Smile a bit more so you don't look angry all the time. You may think these are little things, but those are the things that you are judged on. Because if you go into the court and you're frowning, you're angry on your face, you have a frown on your face as your allegations are being read out, then you look like the villain. So why would the judge not believe all the things that are being said about you? Why would the judge not believe? Right? So all those things matter. You have to know which statements are just, to assist the court in understanding what you want to do. You have to know which statements persuade the judge. You have to know which statements are there as part of your evidence, where you give evidence by writing down your version of events. You have to know how to present them. If you live in the States, there is Father X. If you look him up on YouTube, Father X 2022, I think, is his handle name. He has excellent videos on how to present your story in court, right? So even if you don't live in the States, I suggest you watch that video, you look for it, because there's a certain way you present your story that actually makes it sound believable, right? So it's not just about the truth, how to make the truth believable. Think about it like when you watch a documentary. You still have to show everything from a certain angle to show the truth that you want to say, right? They don't just set up the camera and let it roll because it's a documentary. So you really have to prepare. And I wish I knew this, right? Because if I knew this, I'll have started writing my own statements much earlier, and I'll have started learning how to write those court statements before the court case began. But at the beginning, I was relying on my lawyer for that, and no wonder I wasn't getting traction, because I didn't understand what must go into a statement for it to be persuasive, for me to get what I want. And I didn't understand that that statement becomes um, evidence and becomes part of the framework of my case for whatever period it lasts. For whatever period it lasts. And the same way, you have to take seriously the statements, all statements filed in the case, because that tells you exactly what the case is about from their perspective. You have to be able to see things from the other way. So part of your preparation is actually being able to argue your ex's case. I'm not saying you should go and argue it, but you should know it so well you could actually argue for her against yourself, because that then tells you everything that can be used against you to make it harder for you to see your kids. Now, this is a lot of work. I understand. But I'm telling you what I did. I quit a lot of things, a lot of opportunities I let go just so I could have time to work on my case, because I know that's what matters to me above all, right? But I also understand that it may not be realistic for you to be able to put in all that work all the time. So that's why I've created my service, where whilst you're doing whatever you're doing, I can be working on your case for you. I can study your case for you and help you understand it. Of course, you still have to put in your work. It's not something that I can do on my own because it's your case. You know the situation better than I ever could, right? But there are times where I know the case better than everybody else because I spend the most time with the whole case, reading everybody's statements, you know. Now, be aware that you never know who is your opposition. You never know which kind of judge you get. Sometimes you get a good judge, sometimes you get a judge who's not so good. But the preparation helps you maneuver all of that. And when it comes to knowing narratives, it's understandable that if it's your first time, you don't really understand how stories are told in court. Because a lot of people will deny that those stories are told because they want to pretend that it's a just system. I will not say much about that part. But what I will say is, I'm more than happy to help you. Now, when you get in touch with me, I always give a free consultation that is up to an hour long. That is absolutely free of charge to you, no obligation. It's my way of giving back because, as I said, I was going around collecting free consultations all over the place. And without those consultations, I wouldn't have got to where I got to, and I couldn't afford to be spending 200 pounds, 300 pounds and more per hour to speak to all these people. Like, I spoke to a lot of people. So that's one way of me giving back for the help I received. So if you need help, or you just want someone to talk to that understands your situation, click on the link below to go to bravefathers.com and get in touch. Now, before we end this today, here's what I want you to understand. Your role as a father is fundamental to your child. No matter what the society says, no matter what the child's mother says, and no matter what the child says, you are where the child forms his or her identity. You are the rock. You are the most important person when it comes to determining their confidence in life and their success in life. That is the reality. The ideal picture, the mother and father work together. Unfortunately, you're in a situation where that's not possible. So even when the child does not have contact with you, you must fight to be your best self to yourself, to take good care of yourself, to really do your best to live your best life. You have to do that. Because when you uplift yourself, it lifts the children up. Because think about it, even if they don't get to see you, at least they get to be proud of you one way or the other, right? And it's a painful fight. It's a tough fight. It's a really tough fight, and it's understandable if sometimes you may feel like giving up, but do not give up on your kids. I know I've been to some dark places in my mind and in my soul through the situation. When I look back, I'm like, wow, as if I thought that dark. But it's tough. It's tough. And sometimes you feel like it's not even worth living anymore. But it is worth living. And your children need you. So stay strong. I want to quickly summarize what we discussed today. So remember, the first thing I wish I knew before going to court or before the proceedings began, before going through family courts, of the 5 things that I wish I knew. The first one is it's not about the truth, but it's about narratives, about how you tell the truth, how you tell the story, how you tell the truth, how you tell the story. The second thing I wish I knew is that the facts of the case must be such that you can work a winning strategy. So even your lawyer is as good as the facts of the case. Think of it like cooking. If your ingredients are good, you have it easier cooking a good meal. If they are sour or spoiled or just not high quality, you will struggle to cook a good meal. The third thing I wish I understood and I knew was that the mother will pull you into all kinds of situations. She'll hoover you either by provoking you or by being extra nice to you. Don't fall into those traps. Once you're in court, once she's stopping you from seeing your kids, then you should know what it is. No smile, not even sleeping with you makes up for that. So be aware. Number 4 is that there is a predetermined path that the cases go. Now, which of the paths your case will go depends on the facts of the case and who is involved, but you should be familiar with the possibilities because that way you can prepare properly and you can put things in place to progress it faster. And also don't be fazed by it because you will feel like there is a bias against you, which there is, but overall just see it as the court is going to err on the side of caution. Don't fall into the victim mindset and start thinking of how bad things are because that will not help you. And the last thing that I wish I understood is that your written statement and your preparation in general is what helps you win the case. It's what wins you the case. It's like a sprint, right? A sprint lasts what on the Olympic level, less than 10 seconds. But it takes months of preparation to be able to run that fast. It's the same thing in court. You may be there for an hour or a day or whatever, even 2 or 3 days, but it takes months to be able to perform. So you have to be prepared, and your written statements are the most important things. They are your documents of persuasions. They are documents of persuasion. They are your tools that help you. So, and they also form part of your evidence. So make sure you get them done right. So get in touch with me. Click on the link below to go to bravefathers.com. Get in touch and let me help you win your case. And remember, when in doubt, you are the truth. Bye.
BraveFathers.com